Today we're going to talk about Section 163 and 164 of the Road Traffic Act 1988 and the power of the police to stop motor vehicles on a road. Usual disclaimer, this is for educational purposes. So the power written into legislation comes from the Road Traffic Act 1988, Section 163, and it is the power of the police officer in uniform to stop vehicles. Section 163(1), a person driving a motor vehicle on a road must stop the vehicle on being required to do so by a police constable in uniform. What do we mean by uniform? Well, we take a common sense approach that a police officer who's clearly a police officer with a uniform on that you would recognise as a police uniform, who happens not to have his hat on or her hat on, is still a police officer. So that would mean that a police officer who's forgotten to put their hat on is still in uniform. But it wouldn't apply to someone you wouldn't recognise as a police officer. So you take a common sense and reasonable person approach to it. Number 1632, the power also allows for a police officer to stop any person riding a cycle on a road must stop the cycle on being required to do so by a police constable in uniform. Again, same sort of thing that applies to all cyclists. And that would also apply to anyone who's on a e-cycle. Number 3, the consequences of someone not stopping for a police officer in uniform is that you commit an offence. Some comment now. Don't confuse the power to stop with the power to require production of driving licence, insurance, MOT and that sort of thing. The 163 power does not require the constable in uniform to have any grounds. So don't confuse it with all the YouTube talk of America where they required to have probable cause. Not the case in this country. No need for probable cause. The police have the power to stop anyone and they don't have to give a reason. In theory, the constable in uniform could stop the same vehicle every day for no reason. In practice, repeated stops by the same officer or a group of officers could be regarded as abuse of authority and subjecting them to police disciplinary action. Unless, of course, the driver is committing an offence and continues to commit the offence. So, power to stop vehicles. The power vehicles extends to the normal sort of vehicles that you would think were vehicles. There used to be a definition in 1972 Act, which is no longer in force, that a vehicle was a motor vehicle was a mechanically propelled vehicle intended or adapted for use on the road. That's no longer the case. There are lots of different types of vehicle within the legislation, but common sense, the vehicles we're talking about are cars, motorbikes, cycles, JCBs, tractors if they're intended for use on the road, going between fields if they've got a number plate on them, buses, lorries, camper vans, that sort of stuff. So in detail, what does section 163 mean? Well, we've talked about motor vehicle and bicycle. We've mentioned the word a road. We haven't defined a road yet, but it also extends, you will recall, if you think of the definition, to a road or where the public have access. A failure to stop is an offence under this section, and it has to be a police officer in uniform. So it's got to satisfy all those bits for it to be an offence, not just one of them. So if the police officer, for example, wasn't in uniform, then he wouldn't have the power to stop a motor vehicle or a bicycle. However, if the person did stop and the police officer not in uniform established that an offence had been committed, the fact he wasn't in uniform wouldn't restrict him from dealing with that offence. On a road, we'll deal with the definition of a road in a minute, and a failure to stop is an offence under this section. One 164 is the power of a police constable to require production of the driving licence and in certain cases statement of date of birth. The power extends to any person driving a motor vehicle on a road, or any person who was driving a motor vehicle on the road when an accident occurred owing to its presence on a road, a person who a constable has reasonable cause to believe to have been the driver, and any person whom the constable has cause to believe to have committed an offence while driving a motor vehicle on a road. The section 164 also extends to someone supervising a learner driver who's not themselves driving. That's because there are certain offences of what we call use causal permit, where you can be guilty of a road traffic offence without actually driving. We'll discuss them in detail in a future lecture. To summarise, we know a police officer can require a driver or a learner driver to produce a driving licence because of section 164 if the motor vehicle is driven on a road. If you're driving on a road, then the police can stop you and require you to produce your driving licence. The police do not need to show grounds for requiring you to produce your driving licence. No need for probable cause. That's America. Forget America. We're in England and Wales. You don't have to be doing anything wrong. If a police officer has reasonable cause to believe you were the driver of a motor vehicle at a time when an accident occurred owing to its presence on the road, then a police officer can require you to produce your driving licence. And in this case, you don't have to be in the motor vehicle. In other words, you could have got home, or you could have gone into a shop, or you could have left the motor vehicle. Reasonable cause to believe is an objective test. This means it's what a reasonable person would believe having the same information as the constable. Case law tells us, and we'll go to a case in a second, that anonymous information is sufficient or hearsay information, and all that can be used for a police officer to establish reasonable cause to believe. Ultimately, if there's a dispute on this point, it's up to the court to determine whether a belief is reasonable or not. Dryburgh and Gate, 1981, and that went all the way up to the House of Lords before it became the Supreme Court. In this case, the police got a call about a driver being unfit to drive through alcohol. The court concluded at the time of the stop, the constable did have reasonable cause to believe the driver was driving a motor vehicle whilst unfit because of alcohol. And at the House of Lords, Lord Craigborough, the trial judge was entitled to weigh up that evidence in light of surrounding circumstances and having regard to the source of the information and to draw inferences as to what a reasonable man in that position of an independent observer would make of it. Definition of a motor vehicle is extensive. It's not a simple definition anymore, and it extends from section 185 of the Road Traffic Act up to section 188. It includes mechanically propelled vehicles, not being a motorcycle or an invalid carriage, which is constructed to carry a load of passengers. It also includes if it's constructed for the conveyance of goods and the burden of any description. It goes into different weight categories for the vehicles, and I don't intend to go through that with you in fine detail. It is an extremely complicated definition. Suffice to say, you could use a shorthand definition is it a mechanically propelled vehicle intended or adapted for use on a road? And the answer generally will be yes. Even if it's electric, it's mechanically being propelled. The wheels are turning. More importantly, the definition of a road. Under section 1921A of the Road Traffic Act 1988, a road means any highway and any other road to which the public have access and includes bridges over which a road passes. The difficulty can be establishing whether the public have access at the material time if it's a privately run road. Toll roads clearly aren't owned by the public and are privately owned, but by paying a fee, the public get access, so they would fit the definition of a road. Again, bridges such as toll bridges, tunnels such as Mersey Tunnel, etc., they are all roads under section 1921A. Where it gets complicated is when you are considering what is a road that is private for some of the time and public when the business or the premises is open. And that is where it can get tricky. A highway, which has got a common law definition, is a highway is a way over which there exists a public right of passage. That is to say, a right for all Her Majesty's subjects at all seasons of the year freely and at their will to pass and repass without let or hindrance. So like a public footpath, but extending to the right to use vehicles without any need to have consent. It is an established highway. In relation to a road, however, under 1921A, the definition includes a highway and any other road which the public have access, and includes bridges over which a road passes. So if the road is open at the material time and all the public have access and it's not restricted to visitors only, etc., then in those circumstances it would be a road under the definition. If, however, it had restricted access specifically for employees of a business only, or employees or people who have been given prior permission to enter and have had to go through a checkpoint, then of course that would make it not a road. Thanks for listening. Subscribe please to this channel, Law Rights and All That. We're on Facebook, you can like us, and we're also on the internet. Thanks for listening. Bye.